We do. We do indeed. We need more paper in this case.
I feel like I've been banished.
Well, the last person who sat there actually was the court reporter, so she had to separate so that she has some room.
Oh, I see.
You only feel that way because you haven't seen my office.
Yeah, I have seen your office. I have seen your
I
office.
don't think we need two more pieces of paper.
Okay, cell phones down. Are we expecting other counsel?
Yeah, actually, Sasha Gaffney was supposed to come.
Okay. I was just checking.
So,
We'll give her a couple of minutes, and then we'll get started.
So everyone will just have to remember to turn their mics on if it's not on.
Is it-
Might be green.
It's a little-
Green is on, right? Yes. Bright green.
Yeah, there's two shades of green.
Ah, voila.
That one tripped me up before, too.
Bottle up 2 minutes.
Thank you.
Sure.
We're waiting for counsel.
Yes.
Have we gotten any indication whether or not they're coming?
I was told yesterday that Mr. Martin was sending Bat from his office.
Miss who?
Bat, I think that's what his name.
Battle. Yeah.
Bat.
Okay.
One of his attorneys one of his attorneys in this firm.
So perhaps we do what they do in the university. Was it 10 minutes for a
yeah.
professor?
Well,
Yeah.
Professor, 10 minutes.
It's 1:05 now. We just will wait one more minute, and we're going to go ahead and get started. As I understand, you had contact with Mr. Martin yesterday, so it's not as if they're unaware the date, time, and location of the hearing. Blinking light mean it's recording. Okay, let's just go ahead and get started. Welcome everyone to a special meeting of the Board of Ethics and Government Accountability. Today is July 2nd, 2014. It's 1:07 p.m. and we're located here at room 540 South at 1 Judiciary Square, which is the board meeting room. We're here today on one matter only, which is a pre-hearing conference in the matter of In Re Mary Oates Walker and Kiyo Oden Tyson, case number 1060-001. If counsel could identify themselves for the record, and you could sit during this entire proceeding. There's no reason to stand, unless you're more comfortable, but by all means, please stay seated. Beginning with the Office of Government Ethics.
Darrin, Sobin, Director of Government Ethics for the Office of Government Ethics.
Stacey, Patel, General Counsel.
Anthony Conti on behalf of Mary Oates Walker.
Great. Thank you very much. Before we get started, I just want I'll go over kind of what the outline of the hearing is going to be in a moment, but I just want to clarify, what are we calling your client? Is it Ms. Walker, Judge Walker? I want to be deferential and appropriate, but what would she prefer? At the moment, at least, I know she's not here today, but how would you like us to address her?
I think Judge Walker is fine.
That's fine. I want to be deferential.
Sure. Appreciate that.
All right, so here's how the hearing is going to proceed today. We have a hearing set, an adversarial hearing set for July 14th, so a little bit less than 2 weeks. What I'd like to do is first review the status of the pre-hearing statements that the parties have submitted, identify the outstanding issues that have not been resolved with the order that we issued last Friday, June 27th, then go through the witness proffers, talk about the outstanding motions in limine, then any other issues you have, and then we'll talk about hearing logistics, just to make sure that we're all clear on the mechanical things. And speaking of mechanical things, I'll note for the record that this hearing today is being recorded thanks to our new handy-dandy system here. So we have an audio and video recording going on. It is not being live streamed outside the hearing room. It's a public hearing, so anyone can walk in, but we're not sending it anywhere. We also do not have a court reporter, which is fairly standard practice in D.C. Superior Court for a pre-hearing conference or pre-trial hearing, to have everything recorded on in audio tape. And if need be, for whatever reason, if we ever needed a transcript, we can make one from the audio and video recording. All right, so pre-hearing statements. On March 3rd, the board issued a pre-hearing order directing the parties to meet and discuss a number of issues concerning the scheduled hearing and to submit a joint pre-hearing order. The dates of that initial pre-hearing order were amended, but not the substance. Separate pre-hearing statements were submitted along with motions in limine on June 20th, 2014. The order had asked for a joint pre-hearing statement. I understand the parties were not able to make that happen, which was fairly disappointing, I have to say. And we directed the parties to get together again, file a joint statement by the 25th to see if any further progress could be made. We did get a joint statement, but there was really no simplification of the issues and no stipulations. The responses to the motions in limine were filed on June 27th, and on that same day, the board issued an order resolving a number of requests and motions that had been raised in the pre-hearing statements. So let's go through the pre-hearing statements. I'm going to walk through them quickly and just put on the record what we've done so that everyone's clear. OGE submitted a pre-hearing statement. It contained numerous offers of stipulation, but none apparently that were agreed to by respondents. It did raise a couple of issues, not specifically in motions, but we treated them as such and resolved them in the order that we submitted. The first one was raising the issue about redacted documents, which were apparently redacted in white, and they're concerned they could not see where the redactions were. As I understand it, that amounted to one document. But to the extent that it was more than one document, as long as all redactions for purposes of discovery and certainly the hearing itself, since there will be public records, need to be made in black so we know where the redactions occurred. That was contained in the order we issued on June 27th. There was a request to admit certified copies of bank records without a custodian, having a sworn affidavit from the bank. We resolved, we set forth in the order our view on general admissibility of documents during the course of this hearing, and I'll repeat it here on the record, which essentially is documents that have been produced by the government, by a business, by an individual, will be presumed to be authentic unless there's a specific challenge with a specific reason to challenge their authenticity without the need for custodian of records. The APA, the Administrative Procedure Act, provides that hearsay is admissible, reliable hearsay is admissible, including documents. And so we don't see any need to be bringing in, especially for certified copies, custodians simply to say that they're certified copies. Parties can always object on grounds of relevance. And if there's a reason to doubt the authenticity of a particular document, we're happy to hear that as well. But if it's just bank records or emails that were produced by Octo or an individual, we're going to presume them to be authentic unless there's a reason to doubt them otherwise. There was an action item or request to preclude the use of news articles, and it was not clear to me that there were any news articles that we were talking about here other than those relating to the issue involving Judge Inez Smith Reed, and to the extent that there are other issues with news articles, we'll take them up as individual issues relating to the authenticity and relevance of documents. We resolved the issue, and I'll talk about that in a moment, about the motion involving Judge Inez Smith Reed. There was a motion to request, there was a request in OG's pre-hearing statement requesting that we preclude respondent Oden from introducing new documents because she had not complied with the deadline for submitting to other parties the documents that she intended to use at the hearing, and we granted that because we were well beyond the deadline for which those documents had been granted, and actually we had received no request to admit other documents. We'll talk about witnesses when we get to the witness proffers. But as to motions in limine, there were several motions in limine filed by the Office of Government Ethics. The first one was a motion to exclude evidence related to the administrative law judge's efforts to unionize or their membership in a union. We took that under advisement. We're going to actually discuss that later today in this hearing. The same thing with Office of Government Ethics motion to exclude evidence relating to whether any of the signatories leaked the June 13th, 2012 letter to the media. We'll take that up also with the outstanding motions in limine. We granted the Office of Government Ethics motion to exclude references to former Corporation Counsel, now Judge Inez Smith Reed, as being not relevant to anything that's going on in our hearing, both different on facts and different on the law. And that order stands. There was a motion to preclude the exercise of attorney-client privilege concerning any communications between Ms. Oden, Judge Walker, themselves in their capacity as General Counsel and Chief Judge of the Office of Administrative Hearings, as well as communications between Ms. Oden and Judge Walker and Leftwich and Luddaway. The board denied that without prejudice, but we received a renewed motion last night on different grounds, which I think we need to discuss at some length. So we'll take that up with the outstanding motions in limine. I understand that respondents have not had a chance to I don't know if they read it or even respond to it, but we'll take that up at least in framework. Are you here on behalf of Ms. Oden?
Yes.
Okay. Why don't you join us up at the council table?
And I do apologize for being late.
Can you identify yourself just closer to the microphone so we know who you are?
Sasha Battle, attorney for Ms. Kiyo, Oden, Tyson.
Okay. Two things. One is we really start on time. We waited that 7 minutes for you to get here before we even began. Everyone has a lot to do, and I would really appreciate it if counsel would be here on time. Thank you. So just for purposes of consistency, how would you like us to refer to your client? Ms. Oden Tyson?
For now, we can do Oden, Tyson.
Certainly. we are, to catch you up, we are reviewing the pre-hearing statements and what the board has done thus far. And so far, we've only spoken about the Office of Government Ethics, their pre-hearing statement. Those, I believe, covered all of the motions in limine that the Office of Government Ethics had. Is that right? Yes. Okay. So then we turning to the respondent's pre-hearing statement.
I'm sorry.
Yes.
We did raise the issue of the witness and respondent's deposition transcripts.
Yeah, I'm sorry. I bounced over that, but
Right.
that matches up later with the respondent's motion to exclude them out, and so but we will certainly be addressing that today. As to the respondent's pre-hearing statement, they raise a number of general objections to documents and the manner in which documents might come into evidence. And again, I think that we have at least set out the framework of the way we're going to handle these in terms of assuming the authenticity of obviously produced documents from businesses, banks, emails, et cetera, unless there's a particular reason to doubt their authenticity. But I do not want to limit in any way any party's ability to challenge the relevance of any particular document, and that can be made sort of as we go along. Once again, there were no stipulations contained in the respondent's pre-hearing statement, although there were a number of requests for admissions, which apparently OGE did not. They were requests for admissions, not stipulations, and so there was no requirement that they respond in that way, given our previous ruling.
But we did in our stipulations
Include.
consider them and include some of them.
Right. I did notice that. There were a number of motions in limine filed by the respondents. The motion to exclude Paul Anderson's and Nancy Hateman's testimony, who were identified as experts by Office of Government Ethics, and there was an objection, a motion to exclude them because there had not been given an expert witness notice, a summary, not a report, things that you more commonly find in superior court practice or federal court practice, and that their identity was not disclosed until late. And Office of Government Ethics responded with an explanation that they are aware of the witnesses, and they also responded with a summary of their testimony. So we denied the motion to exclude without prejudice to renew it based on relevance. When we get to the proffers, if there's any particular relevance objection, we can take it up then. We denied the motion to exclude Clara Olawunmi's testimony for the same reason, essentially, which is there's no reason to exclude it up front. If there's a relevance issue, it can be addressed momentarily. The motion to exclude the ALJ deposition transcripts will be taken up sort of in an omnibus way with the ALJ issue. It seems that there are 3 or 4 moving parts with the potential testimony of the administrative law judges, and we'll take that up with the motions in limine. The motion to exclude respondents' deposition transcripts, we denied that for various reasons. One is that they're classic statements of a party opponent, and so they would come in on that ground alone, but they're also evidence in the case. The statements themselves form the basis of several counts relating to material misrepresentations. So that motion was denied. The motion to exclude records that were not timely produced, we also denied that, given the fact that Office of Government Ethics did in fact produce them within the revised timeline of the order, given actually they produced them back in March, but then certainly by the revised timeline as a result of the stay that was imposed by the Superior Court. And the motion to exclude bank records, again, we denied it from an authenticity and a process standpoint. That is to say, the complaint that Judge Walker was not notified in advance, or Ms. Oden Tyson was notified in advance, is not required because they were obtained during the investigation phase, not during the hearing phase of the case. And to the extent that any that you have objections as to relevance, we'll take them up as they actually are presented. So after we got these pre-hearing statements, we sent you back to try to do it again, and there was no further narrowing or stipulations of the issues. I might try to revisit the stipulation issue momentarily when we get to the witness proffers to see whether there is anything that can be done on that score. Okay. So did I miss anything in the respondents' motions in limine? No?
I don't think so.
Okay, so is by the bidding, according to my records here, is that there are 4 motions that remain to be discussed. The motion to exclude the evidence of the ALJs to unionize their membership in a union. The motion to exclude evidence that the June 13th, 2012 letter was leaked to the press. The motion to use ALJ deposition transcripts in lieu of testimony, and the renewed motion and the underlying issues relating to the attorney-client privilege. Am I missing anything aside from the witness proffers? Okay.
Nope.
Ms. Latham, Ms. Richards, anything else? Okay. So then what I'd like to do now is go through the list of witnesses that each of you have identified as your primary witnesses, not the secondary witnesses, not the, what-if witnesses, just the ones that you intend in your respective cases in chief. And if you could give me a very brief proffer, just a few sentences, and then I'll go to the opposite side of the room and see if they have any objections to relevance. If not, we'll just move on to the next one. If they do, then we'll see whether we can resolve it right here and now so you can be prepared for who you have to bring and who you don't have to bring. All right? Okay, your first witness is listed as Kiyo, Oden, Tyson. We'll just assume the relevance of that one.
Okay, thank you.
Don Eichens,
Yes.
is that how he pronounces his name?
Yes.
Appears on your list, but he also appears on the respondents list. So, you can give me a 2-line proffer, but I'm assuming they're not going to object. But go ahead.
There are 3 witnesses, Don Eichens, Harris Syed, and Cheryl Pons, who were from the Department of General Services and its predecessor agencies and worked on the entire relocation project for OAH, including issues related to the move vendor. They handled things at different levels.
Okay.
Don Eichens was sort of upper level oversight. Harris Syed was the project manager, and Cheryl Pons for a while dealt with the sort of nitty-gritty details. And so each of them has relevant testimony as to the move project, the move vendor, how the move vendor was secured, what the procurement options are, who said what, et cetera, et cetera.
And just to make it plain, that set of facts relate to
One of the charges in the, a couple of the charges in the
Amended.
notice of violation related to the move and the selection of the move vendor and the deposition testimony on that.
Okay. Now, Mr. Conti and Ms. Battle, those same 3 witnesses, Don Eichens, Harris Syed, and Cheryl Pons, appear on your witness list as well. I'm assuming that you don't have any objections to relevance, then?
Correct.
All right. All right. Monica Parchment.
Ms. Parchment was the 3rd partner, along with both respondents, in the MKM Ventures LLC. And so she speaks to how the business was formed, how long it went on, what it did, money flowing in and out of the bank accounts.
I understand. Is there any objections to relevance?
No.
Okay. Elizabeth Hunley.
Ms. Hundley is from Industrial Bank, and she speaks to who the names are on the opening account paperwork, who the signatories are on the bank account, and information that she's provided to Ms. Walker when she called about it after her deposition testimony. And so, again, these relate to statements that were made at Ms. Walker's deposition.
The content of Ms. Hunley's expected testimony, has that been provided to the respondents? It was in discovery somewhere, a report, or I'm just wondering, are they aware of what she's likely to say?
If I recall correctly, sorry, it's been a while, when we interviewed her, it was not really an interview because at that point we were in hearing prep mode for the prior.
Understood.
So I do not believe, as I recall,
Okay.
that there was a summary.
Right, so there's not, what I'm looking for here are ways to stipulate the things, but it sounds like if they don't have that concrete, then it would be,
It's gonna be a little-
it'd be kind of unfair for me to even turn to them and ask
Right.
about a stipulation. All right, but I
That
will.
being said, her testimony I expect to be extremely short.
Okay. But I will ask whether you have an objection on grounds of relevance.
We have an objection on grounds of disclosure because we haven't been provided with any type of proffer about this witness. My understanding has been that my client spoke with Tina Carter. We provided a declaration to Tina Carter. So this witness, I don't recall ever seeing this witness named, listed, any type of explanation of what she's going to testify to.
Well, her name has been listed, as I said. We didn't interview her in the investigative phase.
Right.
We
Well-
talked to her in the context of what her testimony might be in witness prep. No memorandum was prepared.
But her name was disclosed. And clearly you had contact with folks at Industrial Bank, 'cause if you've got someone on your witness list from the bank as well. Is that right?
Well, her name was disclosed, I think, as a witness.
All right, well, the question is, right now, and that's why we're doing this here today, to make sure that we're kind of clear about where we're going and who's relevant. If there's an objection as to relevance at this point, such that we should not even have her in the room, I'd be happy to hear it. But otherwise, we'll just add her to the list and move on.
And not knowing, what the information is that she's going to provide, I would say, I would reserve on relevance.
Okay, well, then we'll have to raise that issue when she's here, because at least as a prima facie matter, if she had conversations with your client about the signature of the bank after deposition, that seems to be relevant.
Well, I'm sorry, but what was provided in discovery was what she sent to Ms. Walker after their conversation.
That's fine. I don't think there's any real question that her testimony is relevant. Johannes Fuller?
Mr. Fuller worked for OAH, and he, on the OAH side of things, was partly in charge of the project of the relocation and liaisoned with the DGS people on handling the relocation. And he, at some points, was in contact directly with TPM Group, received the proposals from them for the move.
All right. Any issues to relevance? Counsel? All right. So Nancy Hateman, can we do them both, the two experts,
First.
Nancy Hateman and Paul Anderson?
You want me to do?
Just so you do Nancy first and then just go right into Paul, because I think we'll talk about them as a group.
Well, Nancy Hateman is a long-time employee of the district who has an expertise in contracting and procurement. She will testify, as we said in our papers, about procurement rules and practices in the district, what methods of procurement are available in various situations. We want her as an expert so that she'd be able to offer her opinion as to what options were available in under these particular circumstances, and whether any information that was not disclosed or that came out later was relevant to any determination that she would make in her role, which she didn't have in this case, in terms of advising agencies as to what's proper and not proper, and what things they should consider and what they should do if this and that.
Okay. And Mr. Anderson?
Mr. Anderson works for the Maryland Department of Assessments and Taxation. And as we know in this case, the MKM Ventures LLC that was formed in Maryland was forfeited in 2008. And so we wanted him to be able to speak to, as a practical matter, what forfeited means, what happens to the company and its operations after that. And we thought, although he wouldn't opine on anything legal, he might be able to point to relevant statutes to assist the board, just because he knows them.
So really, as to Mr. Anderson, he's more, he does have expertise, but he just has fact knowledge of Maryland law, right?
Correct.
So that's really what he's giving us. So it's not.
Well, and the practical side as well. So, like, for example, so the company is forfeited. If the company owns something, then what happens?
Right, but that's based on his factual. He has fact-based knowledge of that stuff, as opposed to his
Of how it's
opinion
applied.
about what happened. Okay.
Right.
All right. Okay. Aside from the process part of this about notice, about expert testimony, which obviously now have a summary of this, what is your argument about the relevance of both Ms. Hateman and Mr. Anderson's testimony?
Well, leaving aside, we've had no disclosure of their opinions. It's difficult to object to the breadth. Nancy Hateman has been proffered to offer expert opinions on procurement laws in the District of Columbia. There's an entire agency dedicated to that. I've got to imagine that the code and regulatory provisions that she could be speaking to are voluminous. That's not a disclosure. That's not a proffer as to the particular opinions that she's going to offer. I don't know what procurement expertise is relevant to this proceeding, because this proceeding is not relating to any person who was engaged in procurement practices on behalf of the district. The allegation is that Ms. Walker somehow influenced those practices, not that she was a procurement specialist, not that she had procurement power or engaged in procurement.
But wouldn't it help the board to know what the regular process was and who the players would normally be, to see what kind, if there's an allegation that Judge Walker influenced or attempted to influence that process, wouldn't it help the board to know what the regular course of that process is?
Factually, it would be relevant,
right, and
that would only come from a fact witness. And there are multiple who were just listed. Don Eikens, Harris Syed, Cheryl Pons. Those are folks who work directly for DGS, who can tell this board what the actual practice was, what the actual procedures were, what was followed, what wasn't, how they interpreted them. That's what's relevant in this proceeding, not what someone from the Attorney General's office who's working as an attorney with counsel is going to then suggest and opine was improper.
I agree with half of your point. So I think that Ms. Hateman is General Counsel of OCP, Office of Contracting and Procurement. And the process by which things are procured are sometimes different than the way that the agencies themselves, agencies are just doing whatever their thing is. So DGS is doing their government service building stuff, but they're not they follow someone else's guidelines or guidance in terms of procurement. So I understand that Ms. Hateman has lots of knowledge in the same way that I think Mr. Anderson has lots of knowledge about what happens with the law as they deal with it day in and day out and what is available. So to the extent, I'm not sure what opinion beyond an explanation of the procurement practices or a way in which this contract might have been procured, could have been procured, Ms. Hateman may give. I do think that part is relevant, because I think that whatever Judge Walker, however the allegation she attempted to influence that process, it is helpful for the board to know this is the way it goes, independent of DGS, because DGS just executes the thing that the contract is supposed to do, but it's OCP that sets the guidelines and the guidance. So I think that Ms. Hateman's fact testimony, I'm not sure what the opinion is going to be and whether that is particularly relevant, but I do think that the fact, the description of the procurement process would be relevant to our discussions.
Well, a few things. That first and foremost, this is not the board or body that regulates procurement practices in the district. And that's separate and apart. And so if this were a procurement enforcement proceeding, that sort of expertise might be relevant. We're at least two steps removed from that. What's relevant is what my client knew about the procurement practices, what DGS knew and conveyed to my client, and what, if any, involvement my client had in that practice. So if the Office of Procurement wasn't involved, this person has no relevant facts. She has no firsthand knowledge of anything that occurred in this case. So what she's attempting to do is come in and to educate this board about something that, for all we know, no one involved in this matter was educated about. And when you have two steps removed, an agency going to another agency that's charged with procuring and charged at least with some knowledge of those procurement practices, if that agency itself doesn't know, I don't think you can shoehorn a violation in second, 2 levels removed to a subsidiary agency.
I'm not so sure that's right, because if supposing the particular person at DGS thought that it's totally appropriate to be having a chat with someone about directing a contract because they don't know any better. But that doesn't excuse Judge Walker's conduct in the process, and that gets defined by what a proper procurement practice is. So I think that the facts are, I'm not quite sure that her opinion is coming in on anything. So she may, the title expert may be, for evidentiary purposes, may be removed from her title, but I do believe that it's relevant to have a fact-based explanation of what proper procurement practice is so that we understand what the allegation is about how she may have influenced that process.
Can I ask a question here? Ms. Patel, will Ms. Hatman's testimony overlap with Mr. Anderson's?
No, they're on completely different issues.
Okay.
Yeah, because Mr. Anderson has to do with the Maryland
Right.
Corporation.
Ventures.
Okay. All right. And so this is the only witness that we would have on what proper DC procurement standards are.
Yes, except to the extent that the DGS people, the 3 DGS people, some of them will talk about their understanding and their practice, but she's the person who has oversight over the district, who gives this advice to agencies when they call to ask, and can speak to what the proper processes are.
What this may reveal hypothetically is that DGS people were not following what she would state as proper rules. I'm not sure where
it leaves us, right?
in terms
Right.
of this resolving the allegations. in
Right.
this case. The only sort of relevant thing I might say, and I'll draw a parallel, like there are certain things that, like there's ethics training given, and persons are charged with knowing what's given in the annual ethics training. Whether or not they remember the next day or not. So if this witness is going to speak to some standard of expectation, like employees who are maybe not just DGS folk, that might be relevant, but I see this more as like a fact witness.
Right.
What's the state of the law and what are the expectations that apply to people in the position of respondents?
And if I may, I think what the board members are hitting on is not, we're arguing over is this fact or is this expert or is this opinion. What this witness is going to basically do is testify to the board what the law is. Mm-hmm. Here's the regulation. Here's the statute. Mm-hmm. There's no reason why we can't just have the law admitted. We don't need a witness to tell us what the law is. Well, if she puts her spin on it, then that's opinion, and I don't think it's appropriate opinion.
Well, okay, so here's what I would say. Is a minute ago you just told us that there's a gazillion procurement regulations out there. We only need to know what we need to know in order to move forward.
So put forward, and that's what the Office of Government Ethics is not doing.
But who's going to tell us what we need to know?
The Office of Government Ethics.
We should trust their interpretation?
Well, they're charged with providing my client with notice of what violations she engaged in. And if it's a procurement law, they should identify the law and put it into evidence so that we can all read it and we can argue.
Right. Well, here's the thing, is that the person who's the most knowledgeable about it, presumably, is Nancy Hageman. She's going to be here to tell us, in hopefully a streamlined fashion, the laws. We'll look at them. We don't have to accept everything that she says. We'll look at them, but at least we'll have the relevant universe of what we're supposed to look at.
We don't have that relevant universe. That's the whole problem. We don't have the laws that OG is essentially saying our client violated through this procurement. That's no notice. That's an absence of notice of the legal violation.
Let me ask you this. So if Ms. Hopman, is that her name?
Hapeman. Hapeman.
Okay. If Ms. Hapeman, is she going to basically give you any kind of outline of what the specific laws are that she's going to be testifying about?
There are, I recall correctly, 2 that she's going to mention and explain a little bit. Honestly, I was not planning to put them into evidence or leave them for you to read.
So
and
then,
through.
so you're boiling it. But
Talk about what the.
But I'm saying in the procurement there are volumes of procurement rules and regulations. So is there some way that you're going to narrow this down so that the respondents know where Ms. Hateman is going to be focused on in terms of what the relevant procurement laws are in this matter?
Excuse me.
Okay.
The relevant issues in this part of the case relate to what the procurement methods are when you need to procure services like the services that were procured in approximately the amount that were procured in the time period that you have. And that's what she's going to address. They are all things that have come up in the context of the DGS people and all paperwork that was turned over in discovery and the little witness statements, et cetera, et cetera. Nancy's Hateman is just going to talk about it from her perspective, not having been involved in the procurement of just these are the options, this is where you use this is where you use that, this is what applies, if you have this situation, this is what you would do, et cetera, et cetera.
So, and I guess all I can say is that to the extent that you have been aware of her name and now you've got a summary of her testimony, is that if you want to reach out to her as well, you're free to do so. I mean, the OG doesn't own her, and you can speak with her about it. But there's no separate rule that's required to give anything more than but for this hearing, you wouldn't even have the more extensive proffer. So,
I think we would. I mean, I think we're entitled to all the notes from counsel that counsel took, and all of the statutes that counsel was provided by Ms. Hateman. I think we're entitled to that, and we haven't received any of that.
There is no interview memo. PrEP is attorney work product. She did not provide us with statutes.
Okay.
Well, based on that, this witness may or may not have,
much to offer.
But we'll see where it goes. I would say that one thing that this person might be able to tell us that I would expect to find useful is the extent to which actual practice departs from rules and the level of discretion available to agencies in applying the rules. That is something that she probably would know that cannot be provided by submitting the rule book.
Right. All right. Well, I think there's no doubt that her testimony is relevant. We'll have to reserve any attempt to elicit an expert opinion, depending on what the nature of that is. But
I would ask for the production of the 2 or 3 statutes that were just referenced by counsel. I think in fairness, we should at least have those in advance. I don't know how we can cross-examine this person or provide testimony on a statute that we don't get until the hearing or a reference to.
She didn't provide them to me. Didn't ask her for them. She didn't provide them to me. You can do your own research. I don't have to do your research for you.
All I would say is that everyone just needs to follow the discovery rules. If it's something you have, you turn it over. If you don't have it, you don't have it. And then you don't need to create, neither side needs to create documents or find documents that are available to the other side. And you're free to obviously contact Ms. Hateman and see what she intends to say. Sherry Beatty Arthur.
Miss.
Yeah, yeah.
Oh, I thought we had resolved Mr. Anderson because it was just fact-based. Is there anything?
Yeah, it's fact-based.
I don't think he's fact-based at all.
Okay.
I think
It's the same issue as Ms. Hateman.
it's even more legal opinion exclusively. The proffer that was made is that Mr. Anderson is going to testify what it means when a Maryland entity is forfeited. That's expressly regulated by statute, and there's case law on it. All this individual is going to do is explain what the statute and case law is. That's legal opinion. He's going to tell this body what the law is, and I think the law should come in, not someone else saying what the law is.
We certainly are able to read it for ourselves, but having someone who actually handles it day in and day out, I think would be very helpful to the board and certainly relevant.
I don't know how an employee of the State Department of Assessments and Taxation handles day in and day out.
Well, if it turns out that the Office of Government Ethics is wrong about what his role is and what he knows and what he does, you'll object and we'll sustain it.
And same objections then with Hateman. We've had no opinions produced.
Right.
no summary notes, no statutes that he's going to testify to, and no notice.
Sherry Beatty Arthur.
So Arthur is a former employee of the Office of Administrative Hearings. She was one of those three, I think it was, executive directors where they talked about the constant overturning of the position.
I'm sorry, executive director?
I think that was the title.
Okay.
Just don't hold me to it if I messed it up. But it was a part of in the June 13th, 2012 letter where they talked about the revolving door of not being able to keep good people. She gives a nice overview for her time period of sort of what life was like at OAH, what her position was and what it was supposed to do, and what problems came up in management and operations.
And this goes to?
The some of the issues that are in the June 13th, 2012 letter.
Going to the good faith basis
Yes,
for the
exactly.
retaliation claim?
Yes.
Okay. Objections as to relevance?
Nancy Hateman's employment period when?
It's Sherry
We're talking about
Beatty.
Sherry Beatty.
Sherry Bates Arthur's employment period when?
And I'm sorry, I don't remember off the top of my head, but if I recall correctly, we interviewed her and there's a memo.
Okay.
Be in there.
But
Right, but when was she employed?
all right, well,
I think she was.
I don't remember the dates off the top of my head.
so the issue is she was there during the period of time when OG is going to allege that there were issues that led to the letter, thereby
Led to the concerns.
to the concerns
Expressed in the
expressed in the
letter.
letter, thereby supporting the good faith basis for the signatories to send it, which is an element of the whistleblower retaliation part of this. Is there a relevance objection? The details of which you can work out with OG if you can, but it's the relevance that matters.
Yes, because I'm not sure that she was there during any relevant period or has any relevant testimony. The proffer was just she's going to talk about her life at OAH.
I'm assuming
She was
the
there during Chief Judge Walker's tenure.
Okay, if that she was there, then that's clearly relevant. Administrative Judge Wanda, Acting Chief Judge Tucker.
I'd like to group these a little bit if I could.
Actually, you know what? Maybe we should postpone all the ALJ
Okay,
talk at
that's
the
fine.
same time.
That's fine.
Joan Davenport?
Is also an ALJ. So is Erica Pearson, Steve Wellner, and Just Good.
Okay, so then with Brian Flowers.
Yes. Brian Flowers, as you know, is the general counsel to the mayor. He will speak to issues relating to the retaining Leftwich and Luttaway, the Leftwich and Luttaway scope of the investigation, the report. It's been said that he was the one who directed the Leftwich and Luttaway investigation, so he will address that. He was also the mayor's representative on the advisory committee to OAH, so he had some knowledge of some of the issues that were arising. He and that advisory committee had a presentation of the Leftwich and Luttaway report by Leftwich and Luttaway just before it was released. He was the person who sent the Leftwich and Luttaway report to the cost, had interactions with the cost.
Okay.
So it relates to.
Is there any relevance objection to Mr. Flowers?
No.
And Clara Olawunmi?
Ms. Olawumni is an investigator in our office. She was the primary investigator on the investigation. She worked on all aspects of it. I put her at the end because I don't know for sure whether I will need her, but I wanted to keep my options open. But to the extent that she gathered records during the investigation that I may need to put into evidence through her, I have her on there for that. To the extent that she interviewed someone, had a conversation with someone that has relevant testimony, and I need to put it in through her, I would do that.
All right, so at the point at which you're going to call her, we can have you can make another proffer as to what you expect her to testify to, because I think clearly she's involved with the investigation, has relevant knowledge directly or secondhand, and so we won't take her off the list, but before we actually put her on the stand, we'll give the respondents a chance to raise any objections before she actually appears, once you have an idea of what you want to call her for. So we'll leave her on the list. Is there an
So
issue?
just not understanding why that's necessary, I also have the option of calling her first and putting everything in evidence through her.
But to the extent that we've asked for proffers of the witnesses and you're reserving your option about how you want to use her, all we're saying is that before she marches in and gets up there, we would give the respondents a chance to address because you had so many open areas with no details, which is fine. I mean, you don't have to nail yourself down. All I'm saying is that we'll give them a chance to raise any issues before, the same way we will go the other direction. And that's the last of the witnesses other than the ALJs, is that right?
Correct.
All right. So as to the respondents list, obviously Judge Walker, Ms. Oden Tyson, numbers 1 and 2. Charlotte Brookins Hudson and Judge Jackson and Judge Quander are all cost members.
Correct.
And so do we address them as a group then? Would that make sense?
Sure.
Okay. And if you could just proffer basically what they're
Well,
generally what they're going to
we've
talk about.
provided the board many months ago and counsel with extensive declarations from these 3 witnesses. That's pretty much the areas that they're going to testify to.
About the cost meetings, Judge Walker's role in them.
Yes.
Okay.
No objection.
Okay, so Mark Poindexter and Ann Yana are both ALJs, is that correct?
Yes.
All right. We'll hold off on the ALJ discussion just for a second. Tina Carter, you mentioned her before with Industrial Bank, is that right?
Yes, and we also have submitted a declaration. It's regarding her conversations with Chief Judge Walker about who was the signatory and how she conveyed erroneous information about who the signatory was to Chief Judge Walker.
Objection.
James McKay with the Office of the Attorney General, but also an ex officio member of COST. Same as the others?
Yes, and
I'm sure there was a declaration there.
no, there wasn't. You actually interviewed him and provided us with a summary, and that's the expected basis that he'll testify to.
No objection.
No objection. Brian Moore with the council, is that right?
Yes, he is a committee clerk for the Committee on the Judiciary, which was headed at the time by now Council Chair Phil Mendelson. He sent an email on June 18th to Chief Judge Walker informing her about when he was first made aware of the letter, that his office didn't release it to the media, as was alleged by at least one of the ALJs. And so we think that's relevant to counts 17 and 18 in the NOV.
I think that we need a ruling on the issue of the leak before
we decide on it.
we can.
Let me just say, just as a factual matter, do you have any? Is this something where if it was coming in, you would just stipulate he would say this, and there was an email that says that?
We're limiting it to the email? I've seen the email, sure.
Okay. So we'll just we'll hold that momentarily till we talk about the ALJs and the leaks. Charles Willoughby.
Obviously, the Inspector General, I think former Inspector General, who conducted the first investigation, or at least the first that concluded on precisely some of the issues that are before this board. We think that investigation is relevant. We think his conclusions reached are relevant because we think they're the opposite of what my client's being charged in the NOV with.
And why do we care what, with all due respect to former Inspector General Willoughby, why do we care what he thinks?
Well, because why do we care what anyone thinks? Why do we care what all of the ALJs that are going to testify about Chief Judge Walker think? Why do we care about?
I guess what I'm saying is the ALJs have they were there during the relevant time and may or may not have relevant facts. We'll talk about that in a second. But former Inspector General Willoughby, he just looked at some set of facts and drew his own conclusions, which are not binding on us in any way, shape, or form. So you're asking us for, he would give opinion testimony that he looked at some set of facts and concluded something?
Well, I think much like you're permitting the testimony of Ms. Hateman, this is a person who on a daily basis for years worked for the district, investigated DPM violations. that are identical, and in this case are identical to what this board is investigating. He certainly has a more relevant experience in that arena, and I think that he can provide at least the way that the district's view of these DPM violations has been interpreted through his office. This board may reject all of those interpretations. This board may reject those years of experience in investigating the same sorts of matters, and this board may conclude that he reached the wrong conclusion as to Ms. Oates Walker. But we think it's relevant. We think he factually is involved in the matter. We think that part of the alleged protected disclosure is that they brought this matter to the Inspector General's office. So we think he's involved. He's involved factually. He's reached conclusions. This board may not agree with them, but we think it's relevant. We think it goes to the same issues that this board's called upon to decide.
We object. To the extent that the Inspector General's office conducted its own investigation, I don't think that I would agree that it's precisely the same issues. I think there's some overlap of issues, but I think it's clear, based on the records that we received and turned over in discovery, that certainly the evidence gathering was not even close to the same as ours. And so any opinion that he could render, or analysis that he could render as to his conclusions on the case, would be based on the evidence that he had before him, not our evidence. He's not been involved in our investigation. He wasn't offered, he's not listed as an expert or to offer opinion. He's listed like a fact witness. So at this point, to be finding out that he's being put forth to present opinions and an expertise in an investigation he doesn't necessarily know about,
and it's safe to
his
assume
was different.
And it's safe to assume that he himself did very little in the actual investigation as opposed to his staff.
Yes, but I would make the same argument as to the staff. Sure. So,
No, but
yes,
just
I
in
would
terms
agree
of
with
this
that.
person.
It'd be several levels removed.
Yeah, I have to say that I'm really, I don't see how what the Inspector General did, found, concluded is relevant to anything that's going on before us here today. Yes, there are some overlap of issues and some overlap of facts, but it is not uncommon for different agencies to have different roles in looking at the same situation. And I wouldn't bring the mayor in to talk about the reasons why he removed Judge Walker or ask Acting Chief Judge Tucker why she removed Ms. Oden Tyson any more than I would ask Judge Willoughby why he concluded not. You can make all the arguments that you believe that he relied upon if you think that the facts are the same, but I don't see how that adds to the mix of relevant evidence that we have here.
Well, I think that the other point that he will probably shed light on is the gravity and the significance of the alleged violations. There are dozens of counts brought by this board against our clients, and all of which carry $5,000 fines, potential criminal sanctions. And I think this board, particularly in light of how new it is, would be well served by hearing from someone who for a far longer period of time considered these types of matters, made these types of decisions on the gravity of the matter, the significance, and so that this board can consider that in terms of if it gets to the point where it's fashioning a remedy or a disposition, can factor that in.
Yeah, the only thing I would say to that, Mr. Conte, is that the Inspector General has no enforcement authority whatsoever. And so all he does is investigate and present his findings to either the agency or a board body like ours for proper enforcement. It is not uncommon, quite frankly, to have the Inspector General say, I think you should throw this person down the well, and the agency to say, maybe not, and slap him on the wrist. So I actually don't think that, first of all, it's not his job. It's not in his scope of responsibility. And we are a new entity. And so we're now 2 years old. And with an enforcement scheme that, quite frankly, is new to him. Also, I would ask, have you spoken to him? Do you know what he would say?
No, I have his report.
All right. Well, I have to say I don't find it to be relevant. It's certainly not material to what the board has to determine. So he will not be a witness in this proceeding. Moving on to Lincoln Tyson. That's Ms. Oden Tyson's husband. Is that right?
Yes.
Okay. And he's the owner of TPM, as I understand it, according to the allegations.
Correct.
Any objection?
No objection, although I think it's something that I haven't heard a proffer, but probably that we could stipulate too.
All right. Well, I'll tell you what. I won't work out a stipulation at the moment. If you want to all discuss it, but there's no objection to relevance at the moment.
Correct.
Vijay Kasimsetti.
He is the vice president of Consus, which is the general contractor that was responsible for the OAH relocation project.
Okay. And what do you expect his testimony to be?
We believe that his testimony will be that a Harris Syed of DGS informed him that the TPM group was the one that was going to be performing the OAH relocation. We think it's relevant to counts 13, 15, and 16 because the contention is that OAH awarded the contract to TPM.
Well, I'm not sure that that's the allegation that OAH awarded it as opposed to Judge Walker had a hand in directing that to happen.
Well, that's the allegation then, I guess, of the signatory ALJs in their June 13th letter to the media.
What's OG's position on Mr. Kasimsetti?
We have no objection, and again, I think it's something we could easily stipulate too.
Okay. Nicole Dillard, Ms. Oden Tyson's law partner, is that right?
Yeah.
Former law partner, right. And just a proffer as to what you expect her to say.
Essentially, or a few of the charges, allegations, and the notice of violation.
I'm sorry, I can't hear you.
A few of the charges and the notice of violation are that Ms. Oden Tyson still performed work with her former law firm, Oden and Dillard. So we would expect we call Ms. Dillard to testify as to when Ms. Oden Tyson stopped working
Okay.
for the firm.
No objection?
No objection.
All right. Okay, so then on the list, we haven't discussed the ALJs, and we have to talk about Mr. Moore. The only one of both lists who we've precluded is the former Inspector General, Charles Willoughby.
Did we talk about Harris Syed?
Yeah, he was part of the original 3 DGS lawyers.
Okay.
DGS employees.
Okay.
Correct. In the very beginning.
We skipped over Pons, Ishans, and Syed for that.
They're on our list.
Because they're on the same list. They overlap. All right, so let's talk about the administrative law judges, and let's also, as we do this, address the motions. There are 3 motions in limine that deal with the ALJs. So we might as well have this sort of omnibus discussion here so we can resolve what we can. And I'm just going to scroll back the clock a little bit so I can orient myself into where we are. As I understand it, as I recall, there was a request by the respondents to depose a number of the administrative law judges. The board granted that request. It got backburnered while we were stayed by the Superior Court and then allowed to go forward. There were a total of 5, is that right? Mm-hmm. 5 administrative law judges who were deposed at the respondent's request. The scope was narrowed to essentially, I guess, 3 areas, really, which were the good faith basis for being a signatory on the letter, whether information about leaking it to the press on or before the date of the letter being sent. And then the third area had to do with whether they had information about Judge Walker's participation in the cost meetings that formed the subject of the retaliation claim. At the time we did we approved the scope of the deposition testimony, we understood through communication from Mr. Grimaldi to Ms. Patel that you were not expecting to call the ALJs at the hearing itself.
No, I'm sorry, that's not correct.
Okay, that was
We
my
only-
understanding.
We only,
Or Ms. Teal.
Ms. Teal.
Ms. Teal, okay.
Right.
All right,
Ms.
now I
Teal
understand.
was the only one.
Ms. Teal.
She was or was not?
We were not.
You were
We
not
planning
intent
to call Ms.
planning to call
Teal.
Ms. Teal. I understand. Okay.
And she's on the respondents list.
She's on the secondary list if the deposition
Right,
transcripts
right.
are
Right, okay.
permitted. But so depositions went forward. You all have the transcripts, or you were there, so you know what they said. We don't know what they said, but they said. So we're now at the pre-hearing stage. OGE has asked to use their deposition transcripts in lieu of testimony and have certain ALJs testify in person.
Just one minor correction. Of the 5 ALJs who were deposed,
Yes.
we're requesting to use 4 of the transcripts in lieu of testimony. One person I would have testify anyway, I think, at least as I sit here right now.
And that's
Judge Tucker.
Judge Tucker, right.
And then there will be other
Was Jess
ALJs.
Good deposed?
Yes.
But you would
Well, I stuck him on here because we didn't have a ruling.
Got
so,
it. I understand.
But
Okay.
I would adjust.
Understood. The respondents have opposed the use of the deposition transcripts and essentially said, look, if you want their testimony, bring them in because we want to have a chance to cross-examine them live. In the meantime, OGE would like us to preclude inquiry of the ALJs or affirmative evidence of their efforts to unionize or their participation in the union, as well as exclude evidence of the leak of the letter itself or evidence relating to the leak.
Let me just be certain that I understand. So there's 3 ALJ issues. One is whether or not those that you've taken their depositions, whether or not they should be come in as live witnesses. The second issue, no?
I'm sorry, I understand a
Yeah,
little bit.
clarify
Our issue was to be able to put in the transcripts of the depositions.
Right.
Yes.
And then, from our point of view, for 4 of the people, we would not
You're
intend to
done.
call them as
Right.
witnesses.
Okay, but I
understand.
thought I heard you say that respondents
If-
wanted those individuals to appear live in
If-
lieu, if the
If
depositions
the
are
depositions are
admitted.
coming in, they want, as I understand it, correct me if
that
I'm
correct?
wrong, you want
Okay.
them in here live. Right.
Okay,
That's
one issue.
That's one issue.
Okay.
Issue 2 is OG is asked to exclude, no matter which way we do this, transcript or live, exclude discussions of or evidence of the ALJ's efforts to unionize, which I understand was opposed by Judge Walker.
Okay, and
And the third one is a motion to exclude evidence relating to the leak of the letter.
okay, and we just provide me some understanding as to
Right.
why you want those excluded.
Yeah, no, that's where we're
okay,
going
that's
now.
where we're going.
You're
Okay.
exactly right there. All right, so talk to me about what you want the ALJs for. What would generally be coming in? Why the deposition testimony as opposed to live, and why the exclusions? And then I'll let them respond to that whole thing.
Talking about it in a group.
Group is fine.
So, we have the June 13, 2012 letter that 15 ALJ signed. And so some of the questions that have come up are, did they have a good faith basis? And part of that is, what did you have personal knowledge of? What did you not have personal knowledge of, but where did your knowledge come from? Why did you sign it? Based on what you did and didn't know, what role you had, drafting the letter, revising the letter, etc. Each person, as came out in the deposition testimony, at least clearly for the 4, was able to talk about, what they had personal knowledge of, what they didn't, where they got their information from, and made things very clear. There was also an issue raised as to when they knew the information as compared to when the letter was drafted and sent, and the ALJs addressed that as well in terms of what they felt they needed to have enough to say, now's the time to put something out there and ask for an investigation. Just want to think, I think there's one more thing. Well, at least on that score, so I don't feel the need to call them again to relate those same anecdotes or that same information that they had. I think it's clear in the testimony. The other issue that came up was in terms of who, as far as the DPM is concerned, who the information was disclosed to, the Inspector General, the agency head, and so they don't all talk about it, but a couple of them talk about having spoken to the Inspector General's office, so a covers that end of it, and one of the ALJs talks about delivering the letter to the chief judge, not by hand, but having
Right.
been responsible for that delivery. So again, that's all covered in those 4.
Okay. So in the counts involving the alleged retaliation, one of the elements is that the persons retaliated against had a good faith basis for making the disclosure that they did. So why isn't it, if there was some kind of animosity, disagreement, that's not related to, that maybe, that the respondents could argue was unrelated to the contents of the letter, the actual concrete complaints, why wouldn't that be relevant? For example, if the fact that they were at war over the unionization of the ALJs, because it was apparently fairly, as I understand it, bitterly argued.
Yes, but it is not illegal to unionize.
Right.
It is illegal to interfere with the process of unionizing. I suppose as an agency head you could resent that your employees want to become part of a union, but you are prohibited by law from interfering with that process. And we did not charge anything related to Ms. Walker's violation of the law with respect to the union, so I don't see how it's relevant.
Well, and I guess, we'll stick with this for the moment. Mr. Conte, why is it relevant?
Well, I think there's a little bit of a broader picture here, and it really relates to all of these issues. If I could have, a moment to sort of outline it for the board. Counts 17 and 18 in the NOV charge Judge Walker with a violation of DPM section 1803.11. That section states that it's, and I'm paraphrasing, but that it's a violation to engage in coercion, harassment, or retaliation against an employee acting in good faith under 1803.8. Now, what's relevant in 1803.8 to a lot of these issues is that it says an employee, and the employee that we would be discussing here are these ALJs that wrote this letter, shall report directly being very material in this action, and without undue delay also being very material in this action, to his or her agency head and to the Office of Inspector General, any information concerning conduct which he or she knows or should reasonably know involves corrupt or criminal activity or conflicts of interest.
Right.
So the allegation that's endorsed in the NOV is that Chief Judge Walker engaged in this sort of retaliation for these not just good faith notices, but good faith notices that were sent without undue delay directly to the agency head. Now, when we speak of communications with the media, and I realize the board doesn't have the benefit of all of our exhibits at this moment, but what we've produced is our binders of the exhibits that we intend to offer in evidence in this matter. They start back at March 29th of 2012. So this is months before this good faith disclosure was made, or the arguable good faith disclosure was made. And those communications, we believe, make clear that these ALJs were communicating with the media, not with the agency head, not with the Inspector General, but with the media about all of, or at least some of the concerns that pop up in this June 13th, 2012 letter. The letter itself was provided to the media at the same time that it was delivered to Chairman Mendelson. It was put up on a website, and we have email communications from these ALJs to the media inquiring about when is it going to be up, or are you going to link the story? And we believe we have direct evidence that they were the ones that provided it to the media. We have direct evidence that one of the ALJs contended that it was Mendelssohn's office that released it to the media. And so all of this goes to not just the direct leak of the letter to the media, but the fact that for months ahead of time, these ALJs were not in good faith worried and concerned about an agency issue that they were bringing to the agency head, but instead their interest was to tarnish the reputation of OAH, to spread whether it was rumors, whether they were fact-based, whether they were allegations that had part of the truth, to media members so that they would report them, and their goal was to have the chief judge removed, not a goal to report a particular type of misconduct that would get them shelter. So that's why all of this is very relevant. Now, you ask, well, where does the unionization effort come in? Well, at the point that the June 13th letter was sent out, the concern at the Office of Administrative Hearings was that they have their own ethics code. Their own ethics code expressly prohibits efforts by ALJs to tarnish the reputation of OAH. They're ethically obligated to uphold that reputation, to do so through legitimate means. And the concern at OAH was that they were leaking information to the media, some of which was untrue, most of which was never directed to the agency head or any appropriate body to have the issue addressed and resolved. And the goal was not a good faith, legitimate goal. When that became apparent, the cost board is charged with determining whether or not ALJs should be investigated or disciplined for violations of their own ethics code. And when it became clear that the cost board, and this is on July 16th, 2012, so only 1 month after the letter is leaked to the media and it's printed in the media, 1 month after that, the cost board is notifying these ALJs that they will be conducting an interview. They will be conducting an investigation in this matter. The 27th, 11 days after they're notified that this matter, that they may be under investigation, is when they begin their unionization efforts. Okay? And our argument is, much like there was not a legitimate effort to have agency issues raised in an appropriate manner through appropriate channels, the unionization effort was not a legitimate effort to organize as a labor movement, but was to gain protection because they knew that they were going to come under investigation for their own leaks to the media.
Okay, so now I've been laboring under a misimpression. So maybe you've just clarified something for me. I was under the impression that efforts to unionize began before the June letter was sent. That's not true?
The first letter that I have, and there could be materials that I don't have.
Right.
So I can't say when the effort exactly began. But the first letter that I have where they're announcing that they're being represented is on July 27, 2012. And that's a letter from their...
Okay, so as I understand your argument sort of in shorthand fashion, that the reason that it's relevant is because their efforts to unionize was an effort of self-protection, having made this non-good faith complaint against Judge Walker. Is that right?
That's correct. Now,
because I've been walking around thinking that the efforts of unionization was evidence of bias leading to the letter, but that is to say that they were at war with her in advance of when the letter was sent, and they thought this was a way to deal with it. But that's not the argument if the efforts were post the letter.
And I think that, I don't think that the unionization efforts are going to in any way take center stage, and certainly they're not part of the NOV. But for example, there was a meeting that was set up with the mayor's office, and it's our contention that the meeting between some of these organizing ALJs was promoted as relating to unionization issues. But at the actual meeting, what was discussed was some of the issues that are relevant here, as well as removal of.
But this was also all after the letter was sent, right? I mean, the letter had already gone up at this point. So that everybody was well aware of what the complaints were.
Yes.
Okay. All right. Can you just pause there for a second? Because I want to ask, I've had the timeline wrong in my head. And I'm not saying that this.
I want to say that it's wrong. I wish I had a date and I could give it to you, but I have an impression that the union effort started, long before. I almost want to say they might even started before Judge Walker got there or sometime shortly thereafter, but I just cannot, as I sit here, I can't put a date on it. I don't want to represent that. I would like to just mention two things if I.
Yeah, and I want you to address the leak issue because I didn't give you a chance to talk about that as well.
Well, just sticking with this, I think it's important not to lose sight of the fact that the ALJs are not the respondents here.
I understand.
And that the purpose of unionizing is to protect yourself.
Right. I've been looking at this all as a bias issue as opposed to because of the time frame. I had this in my head as I thought the argument from the respondents is, look, they've been trying to unionize. She's been a roadblock to them. It's yet another reason to send the letter that's not true to try to get rid of her. That's not what I'm hearing. What I'm hearing instead is they started this and they wanted the union to protect themselves, which is a different argument completely. But I understand.
But I can't address it because I just.
I understand.
In my head.
But can you address the leak issue? So what is the harm if assuming the ALJs are here, or maybe they were asked in their depositions, which I'm assuming they were. Did you leak it? Do you know who leaked it? It was one of the signatories of the letter.
The board didn't allow questions into the leak at the depositions.
The leak to the well, I don't have it in front of me, but what there were two. I know that we were allowed
Questions relating to the letter.
right. The good faith basis for the letter and knowledge of the cost meeting, right, but not as to the leak itself. Right. Okay. So, and I've heard the argument, as I understand it, from respondents is, if they're feeding information out or potentially feeding information out months in advance of sending the letter, then that goes to the undue delay and the lack of good faith basis. I understand that. Why is that not right?
Okay, because some of the ALJs talk about, for example, in their deposition testimony, what their timing was. So just as a for instance, one person talked about how, when you see something, it gives you a little concern. You see the same thing again, you're a little more concerned. You see it a third time now, it spans time, now you're starting to see a pattern. That's where you get to, maybe I have to tell somebody and have it investigated. Or I knew this, I knew that, but that in itself wasn't a problem until I learned that last fact. And then I said, gee, that changes things a little bit.
Right.
And they did talk about how some of the things they learned from the media. Then they went and did some research. So they weren't basing it solely on the media, but that was the connection for them. But in terms of the leak, a couple thoughts. First, again, the ALJs are not the respondents.
Right.
I haven't seen anything that proves that an ALJ was a leak. And given how many people the letter was distributed to and some testimony about having given the letter accidentally to the wrong place and trying to serve cost, the possibilities for how it got out in the world are, I won't say endless, but they're enormous.
Here's a question that's been percolating in my head for a while now. Suppose, I understand that no one has evidence of who actually did the leak, because if you did, we'd be having a different conversation right now.
Counsel just said he did. But
Well,
I think we do. I think we have circumstantial evidence that the ALJs were scanning it
circumstantial,
and
yeah.
releasing it to the media.
All right, but we don't.
direct.
We weren't permitted to ask them the
Okay.
question at the
Oh,
deposition.
okay. So we have, but at the moment, suppose let's say hypothetically that one or two or three of them got together and said, "Hey, let's leak this to the press." How does that change anything in terms of what she's charged with? How does the fact that three of the 15 signatories leaked it, how does that change the good faith basis of the other 12?
Well, Well, it calls into question the good faith basis of the group. They acted as a group when they sent this letter.
Well, I mean, the 15 people signed a letter.
Well, and we have April 24th, 2012, several of those folks discussing one of the issues in the letter. And they outline bullet points for a meeting with Mendelsohn. And this is from an email from Jess Good, ALJ. Ask him about the strategy for advancing our cause, parenthetical, while masking our suggestions, close parenthetical. This is when they were discussing 2 months in advance one of these issues and how they're going to mask their suggestions. All of this goes to good faith basis. If we pick apart 3 or 4 or 5 or 6 and they all agree that they were sitting down and they were meeting together, it calls into question the legitimacy of it.
I mean, let's say 14 of them got together and leaked it to the press. The fact that one had a good faith basis, is that not enough?
It may be, but they have to prove that. This is their case. They bear the burden of proof.
Well, they have to prove they acted in good faith, right?
And I would argue that sitting down with the council member is good faith. There's nothing that says you have to put your request to the council member to address concerns or consider an investigation or whatever it is in writing.
Okay.
If they were sitting with him in April, that means those issues were out there in the world legitimately long before the letter.
Right.
I'd also I just wanted to make one other comment. Mr. Conti talked a little bit earlier about the cost investigation. And I just would like to mention that the cost was CC'd on the letter as well and did nothing with it then. It was only later.
Right. Okay.
Mr. Chairman,
Yes, ma'am.
I think we're getting we're too much into the weeds and beginning to speculate.
Yeah.
So,
I would like to, and that's a very good point, because what I'd like to do is just discuss the attorney-client privilege issue. Then we're going to break so that the board members can step outside, have a bit of a discussion, then we'll come back in and pick up from there, because then we can just resolve what we can resolve. But I would like to address the attorney-client privilege issue at least to some degree, and then we'll come back with our decision on what to do with the ALJ testimony. So the Office of Government Ethics filed a motion to preclude the assertion of an attorney-client privilege by, as we said in the very beginning of this hearing, Judge Walker and or Ms. Oden Tyson, depending on what direction we were dealing with. We denied the motion without prejudice to renew it because it is very challenging to rule in kind of a global way on the assertion of any particular privilege when you get all these, the person asserting the privilege has a bunch of stuff that they have to demonstrate. They have to just demonstrate that there was an attorney-client relationship or one that was being formed. They have to demonstrate that there was a communication made for the purpose of either giving or receiving legal advice, that it was intended to be confidential, intended to remain confidential, they acted in accordance with that, and that it hasn't been waived or otherwise exploded by something like the attorney fraud exception. So there's a lot of stuff that gets bound up in there that made me, the board, reluctant to say, sure, there's no attorney-client privilege. I think that we can agree, and it doesn't seem like there's any disagreement in the papers, that the privilege belongs insofar as Ms. Oden Tyson was serving as general counsel to OAH and communicating in her role as general counsel to the head of OAH, who was Judge Walker at the time. The privilege belongs to OAH and not individually to any of the people. And so it's government can own a privilege. It's the head of the agency that controls what happens to it. And it's understandable that both of them would assert it until there's some evidence that the agency itself has decided not to do it, if there is in fact a privilege that's there. A renewed motion was filed last night which raises the other issue about whether or not a government entity can assert an attorney-client privilege against the same government. And it's a case where the auditor was seeking to get documents from the mayor. It's trial level opinion, not a court of appeals opinion, but it cites some stuff, has some weight to it. Where it's in that context, the auditor was conducting an audit. The mayor tried not to disclose information based on an attorney-client privilege. And the court eventually said, look, you can't do that because you're the same government, and that's just not going to work. But there is a big difference between that case and our case here, which is in that case, the information was only going to the auditor for purposes of her review and audit and not out to the public, at least not as an initial matter. And there would have been an intermediate step where the city, speaking through the Attorney General, could step in and argue that it should be protected from outside eyeballs. Here it's a little bit different because we are open and it'd be public. So again, I'm left sort of reluctant to decide something in a omnibus way other than coming up with some general categories of things to help give the party some guidance about how we move forward. But we haven't decided, and I'm happy to hear our argument and discussion on this. As a practical matter, I do think that any communications in the context of their working environment between Ms. Oden Tyson and Judge Walker belong to OAH. And it's OAH that gets to decide whether that gets waived or not. There may be some involving the EOM, Executive Office of the Mayor, involving Leftwich and Ludaway, because I understand that they had a role in that representation as well. Maybe they get to waive or not, if there's a privilege at all. And so let me hear you, Office of Government. And I realize that the respondents are at a bit of a disadvantage, but I'd like to at least tee up the argument and see where we go from here on the issue of whether there's a privilege at all.
All right, I'll speak to that. Yeah, as you state, we've cited and attached the Judge Hamilton opinion, and I heard what you said about how we're a little different from the auditor's office, but actually I don't think we're so materially different that it makes a difference here, because I would view OGE as similar to the auditor, in which we do our investigation, and in the course of our investigation, much like the auditor does her investigation, she needs complete access to the documents, to the records, to be able to satisfactorily do her investigation. Now, whether or not that investigation or that audit results in a public document that discloses public or confidential information is a different matter. As you stated, there would be an opportunity for someone to step in at that point. And I think that we are in the exact same position, because the board sits as that last bastion of releasing or not releasing what otherwise might be privileged information. And so, practically speaking, I think the way I would envision it working is going into closed session with the board, and the board would decide at that point whether or not it was something that the attorney-client privilege was intended to protect against. In other words, disclosure to the public, as opposed to disclosure within the government.
So,
Could we hear the response
yeah,
first?
no, I just want to understand the process by what you're saying, so so the respondents can respond accordingly. So let's say hypothetically that Ms. Oden Tyson was on the stand and she was testifying and got to the point at which you were asking her about communications with Judge Walker. We would close the session at that point, take that, and then make a determination about whether it gets opened?
Well,
or we haven't thought that far about how it works mechanically.
it would be difficult, but that would be the safeguard that would be in place. But long before it ever got to that, I guess what I'm looking for here is some ruling by the board that we can use even going forward in other investigations, that the attorney-client privilege does not count, does not apply when it is in the course of our investigation. Now, whether it comes out,
this would be an easy call, to be honest with you, if this were in the context, this issue had come up in the context when it was still a confidential investigation. But we're kind of, that horse has left the barn. So I do think that there's a very strong argument about on the front end. It's the back end that I'm concerned about, which is if we rule consistently with what Judge Hamilton, we found enough parallels here to do that. What safeguard is there to prevent from the escape at large? The thing that was never going to escape at large with the auditor case, at least not initially, there would have been an intervening step to allow someone who thinks that there was a privilege, in that case it was OAG, by the way, to intervene.
My understanding from having experience with the auditor's office over the years, and I talked to them a little bit about this issue just in these last couple of days. Generally speaking, meaning every time they could think of, when they have a completed audit with findings, it becomes public. I have never heard, and they did not say, that they give the Attorney General's office a heads up before they release an audit report. So while you may be correct in a technical way, in that should the OAG get wind of it, theoretically they could opine, as a practical matter, I don't believe that that ever happens.
Right. Although there are draft reports, the draft auditor report is generally circulated before the final one is out, and
Correct.
certainly OAG has the ability at that point to jump up and scream, hey, you're disclosing something that's confidential.
But again, that would be assuming that someone brought it to their attention, because generally the draft audit report is shared with the agency or entity that's been audited.
Right, whose general counsel belongs to the Office of the Attorney General.
Assuming that you're talking about a government agency, the one that was at issue in the case that we're talking about were two outside entities. They weren't government agencies.
NCRC and AWC?
Yeah.
Yes, they were.
Aren't they a little bit quasi-different?
They were owned. They were quasi-governmental, but
Quasi-government.
they were the members of the court. Both corporations were appointed by the District of Columbia, and so they had to operate within it.
But they have, I'm just going to your statement about, do they have general counsels who are part of the Attorney General's office?
Yeah, all right. So here, that audit was. Just for the record, I know way too much about the case because I was the attorney for the auditor. But in that case, it was a statute that directed the auditor, to do the audit and report it to the council, report it to the mayor. But because they were both defunct, they had both been dissolved at that point, and she was sent there to do a closeout audit of them, and the mayor said you can't have access to the records, but the report by statute had to go back to the mayor, and so he was going to get a draft anyway, because generally the auditor doesn't audit outside entities, just governmental or quasi-governmental entities or private-public partnerships that have a public component. So under a normal circumstance, if she was auditing, for example, DGS, it would go to DGS as a draft. The DGS general counsel, who belongs to OAG, would say, hey, wait a minute, you're giving this away. They'd have a chance to do it.
Assuming they saw it and
assuming they saw it, all right. But at least
and did something with it.
Trigger was potentially there.
And that was my point, was
Right,
that it's a potential.
Right.
Maybe
Right.
not always an actual.
So to the extent that the respondents have a dog in this fight, and I'm not sure how much of a dog the respondents have in the fight, what's your position on this?
Well, as much as these proposals sound, reasonable, shutting the doors and going in closed session, you can't unring the bell. This is a contested proceeding. If they're going to introduce evidence of attorney-client privileged information, that is going to work its way into the public filings, whether it's on appeal or otherwise. So the privilege is lost. It's eviscerated. Once, and I don't think it's relevant to decide today whether they could have asked it in an investigatory stage.
Right.
But I think it's the same situation there because the investigation, it's not like an audit of the DC government. You're investigating somebody that you're going to bring charges against, and presumably, if that evidence is relevant, you're going to cite to that evidence, present it to the board, and as a result, the respondent has the entitlement to have that evidence, to contest that evidence, and all of a sudden, the bell's out. It's been rung.
And it doesn't look so great for the board that's in charge of the Office of Open Government to close some of the evidence out and then rely on that at the end of the day.
Yeah.
I'm not, I don't find the Fenty versus Nichols case.
I'm sorry, I didn't.
I don't find Fenty versus Nichols to be persuasive because the circumstances are so different. Because that's a case of like agency records, and this is a case where individuals are at stake in the court proceeding. So, I think that we can sort of put that case aside in deciding this. But I would like to discuss this more with you, deliberate.
Yep.
I just wanted to.
Do you have any questions before we? So we're going to take a bit of a break in a minute. Deborah, anything?
No, I'm
Okay,
fine.
so let's do this. know that's getting late already. Can we come back at 3 o'clock? Is that
No, that's fine.
3 o'clock? And then we'll see if we can wrap this up. We don't have much more after this. All right, so it is 2:41, and we'll recess until 3 o'clock.
I have to use the restroom.
Yeah. We'll go to the conference room.
Okay.
So,
Still got back, it's gonna be gone only the 26th of July.
Okay.
Where did I go?
I thought you guys went to the little room to, maybe they just went to go to the restroom.
Oh,
first.
okay. I was gonna say, here they go.
Yeah. They were gonna leave.
Okay, I'll make a decision.
Yeah.
To Dan.
We're not recording now, are we? I have no idea what that means because that says incoming.
Is it recording right now? It's still even though we're not in session?
Can we turn it off?
Is that easy to do? Oh, yeah. So the way this incoming video, or it says no incoming video and it's a phone. I guess I don't understand how the system works. These cameras here, there has to be some sort of bridge to the phone. Right. Okay. And all we're doing right now is recording. So where does the phone line come in? It says no incoming video, but then there's a phone line. Right. Okay, and so to pause the, because we're using up a lot of. So if someone wants to watch, we have to sit. In the future, we should probably stop it when they go. People want to talk in the room and stuff. Okay.
So let's stop it now. Because I have something to talk to you about.
Why don't we stop that stuff?
Can we just stop the recording?
Yeah, it's not that simple.
Yeah.
Well, there are other